The Magistrates Court. In hierarchy of the courts of Sri Lanka, it is District Court which stands below the High Court. Under the hierarchy of the court established under the Courts of Ordinance number 1 of 1899, the constitution of the courts was as follows: Supreme Court, District Court, Court of Request, and Magistrates Court. Under the Court's ordinance, the District Court also had the power to hear, try, and determine in the manner provided by the Criminal Procedure Code all prosecutions and charges in respect of any crime or offence committed within the district. The criminal jurisdiction vested with the District Court disappeared with the legal reforms brought by the enactment of the Administration of Justice Law 54 of 19th century, followed by the later Code of Criminal Procedure Act number 15 of 1979. Since 1979, the magistrate courts are essentially courts with criminal jurisdiction. Now, the jurisdiction of the magistrate court is found in the provision of the Code of Criminal Procedure Act number 15 of 1979 and other statutes. According to Section 9 of the Code of Criminal Procedure Act number 15 of 1979, every magistrate has subject and in accordance with the provision of the Code full power to hear, try, determine, and dispose of any summary way all sets of prosecutions for offences committed wholly or in part within the local jurisdiction. As aforesaid, the criminal jurisdiction of the District Court was abandoned. The Magistrate Court has jurisdiction to summon such criminals and offenders to deal with this under the provision of the Code. The Magistrate Court is vested with the power to issue warrant and to inquire into cases of homicide. Magistrate has to proceed to the spot to observe the scene as well as observe injuries. Section 143 of the Code of Criminal Procedure Court Act. The magistrate trying to accuse under the Penal Code of offence has a power to award the accused, if found guilty of the offence charged, both to imprisonment or a term not exceeding 2 years and a fine not exceeding 1,500 rupees in that time. Inquiry into non-summary offences. The magistrate also has the jurisdiction to hold what the generally called committal proceedings under Chapter 15, Section 145 to Section 163. It is preliminary inquiry at the conclusion of which, if the magistrate considers the evidence sufficient to put the accused on his trial, he should commit him for trial before a High Court. Mode of addressing a magistrate is say, Madam or Your Honor. A great number of persons charged with offences are dealt with in the magistrate court, and the court has emerged the busiest court among the inferior courts. In other words, the bulk of the work in criminal justice is diverted to the magistrate court. Criminal proceedings either under the offences summary or the other offences under the statute with the criminal element, for example, offences under the excise ordinance or customs ordinance, are launched in the magistrate court. Since the police initiate prosecution under the penal code, the magistrate court is referred to by some, especially by the old generation, as the police court.